Now, what we've been talking about up until now is what to do with criminals once we identify them. Should we impose a death penalty? Should we incarcerate them? Is preventive detention the right way to go? What we're going to talk about today and next week is how we figure out who is criminal. In other words, we're going to be talking about police investigation by the government in an effort to figure out who has committed a crime. Now, we've already talked about that a little bit. Remember, the first week we talked about eyewitness identification. That's one way in which you figure out whether a suspect's a criminal. We also talked a little bit about interrogation. Today and next week we're going to talk much more about police investigation. Today we're going to talk about what lawyers call searches and seizures, searches for evidence and seizures of evidence, and particularly surveillance. And then next week we're going to talk about interrogation. So, searches and seizures and interrogation are the two most prominent police investigative techniques. They are the primary way in which police find out whether someone's a criminal. It's the primary way police get evidence of crime. So it's important to talk about both of those types of police techniques, and particularly we're going to concentrate on what the Constitution says about searches and seizures and interrogation. There's lots to be said about when the police can search and seize, when the police can interrogate. I teach whole courses on this. We're going to focus on what the Constitution says about searches and seizures and interrogation. So starting with searches and seizures, and in particular surveillance, because I think that's the hottest topic right now within the search and seizure category, it's important to recognize that we are slowly but surely becoming a mass surveillance society. Okay, why? For one thing, technology has improved immensely. There's something called the Cold War dividend. What happened is during the Cold War, the United States developed all sorts of technology for spying. Spying on the Russians, spying on our enemies. Well, what's happened since the Cold War more or less ended is a lot of that technology has percolated down to law enforcement agencies, and at a relatively cheap cost. The government did all the research, and now it's relatively inexpensive, so police forces are starting to use some of the technology that used to be reserved for spying on Russians. So that's one thing that's happened. The other thing that's happened, obviously, is 9/11. Okay, 9/11 scared everybody. It made the government really emphasize surveillance as a way of figuring out who might be a terrorist, and so we've seen a vast increase in the use of surveillance, especially using technology for surveillance purposes since 9/11. So I'm going to talk about all of that today, and then talk about the way the Constitution might regulate this. The tension is this, of course. Surveillance can be extremely useful in detecting and deterring bad people, including terrorists, right? That's obvious. Whether it's camera surveillance or tracking or satellite surveillance, there are lots of ways in which surveillance can be very helpful in terms of law enforcement and finding the bad guys. But at the same time, as we'll talk about, surveillance can be very intrusive. It can invade privacy. It can conceivably chill freedom of association and freedom of speech, which are First Amendment values. And so it's really important to investigate how that tension should play out. And of course, the Constitution is usually the way we do that in this country. We look at the Constitution as a way of figuring, what the Constitution says is a way of figuring out how we should balance the government's need to keep us safe with our need to be secure from government intrusion and prying. So let's start with a story. Okay? Ahmad Abdullah, that's the guy's name. Ahmad Abdullah. You know where I'm going with this. He's driving a car in New York. He gets stopped by Officer Jones for speeding. Now, Officer Jones checks out Abdullah's license and registration, and it turns out they're fine. There's nothing wrong with Abdullah's license and registration. On the other hand, Abdullah looks a little nervous to Officer Jones, and he also has the name Ahmad Abdullah, which, for better or for worse, suggests to Officer Jones, maybe you better check this situation out. So what does he do? He goes back to his squad car, and let's assume this is the year 2015, just so we can make sure all this technology actually exists. It's on its way to existing if it doesn't already exist. Let's assume this is the year 2015. Officer Jones goes back to his car, and he activates his Raytheon electromagnetic pulse scanner. That's what this is. Okay? What does this do? It can indicate whether a car, or a house for that matter, has a bomb or weapons in it. So he activates this device to see if there's anything bad in Abdullah's car. Turns out there is nothing bad. Okay, but Jones still isn't sure that Abdullah's a good guy. So what he does is he attaches a GPS device. You've all heard of this, global positioning system device, to the bumper of the car. He pretends to be looking at Abdullah's license plate, but what he's really doing is attaching the GPS device to the bumper of the car. And he also, of course, gets Abdullah's cell phone number. Now, why does he want that? Because that's another way you can track an individual. If your cell phone's on, you can be tracked by the government or by anyone else who has access to the relevant equipment. Okay? So the GPS device and the cell phone number are designed to help track Abdullah, and that's exactly what the police do over the next couple of weeks. They use the GPS device to track his car. They use a cell phone to track where he travels in his car or elsewhere. And they also use closed-circuit TV, CCTV, camera systems located all over New York City. As I'll talk about later, there are probably over 10,000 cameras in New York City right now, mounted on telephone poles and buildings. And they use those cameras to track where Abdullah is as well, at least when he's out on the streets. And sure enough, it turns out, Abdullah not only visits his local mosque, but he visits lots of other mosques too. And that makes the police a little bit more suspicious. Why is he visiting all these other mosques? So what do? They decide to get a hold of Abdullah's phone records and his bank records, just to see who he's talking to, who's talking to him, the kinds of transactions he's engaging in. They get his credit card records too, for good measure. All this is easily available via computer if you know what you're doing. Okay? And so they get that information. And they contact, just for good measure, a private company named ChoicePoint. Anybody heard of ChoicePoint, just out of curiosity? This is a private company that collects information from public and quasi-public records about everyone in the United States. Okay, it sends out people to courthouses and other record repositories around the country and collects all that information and computerizes it, and then makes it available to the government, or for that matter, private companies that are willing to pay for it. So the police also go to ChoicePoint and see what they can find out about Abdullah. And then it turns out Abdullah lives in an apartment in New York City. He sometimes keeps his curtains open. So the last thing the police do is they set up what's called a Startron in an apartment across the way. What's a Startron? It's essentially a magnification device with night vision capacity. Okay, so in other words, they can watch what Abdullah is doing so long as his curtains are not drawn, or even if his curtains are drawn, if they're particularly lacy curtains. They can see right through them, even at night, even if the lights are off, with the night vision capacity of these Startrons. Okay, so that's what the police do. Now, Abdullah, of course, could be a terrorist. That's possible. Or maybe he's just an illegal immigrant. That's also possible. And of course, there's a good possibility he's totally innocent, because so far he really hasn't done anything very suspicious, right? The point I want to make, though, I don't want to tell you what he is right now. I'll just leave you hanging on that point for right now. What I want to emphasize right now is that nothing, with one exception I'll get to in a second, nothing the police did to Abdullah violates the Constitution. The Constitution has nothing to say about anything the police did, any of the searches that the police did for evidence relating to Abdullah. Okay, and I think that's a relatively stunning point to make. A lot of people are surprised by that. Now, why is that? Well, the constitutional provision that's most relevant to this kind of situation is the Fourth Amendment. You've all heard of the Fourth Amendment. It's in the Bill of Rights. And it says what you see here: the right of the people to be secure in their houses, persons, papers, and effects against unreasonable searches and seizures shall not be violated. So notice it protects houses, persons, papers, and effects. And if the police are going to intrude into those places, they have to do so in a reasonable way. Okay, so what's reasonable? As I think I said last week, reasonable is the ultimate legal weasel word. If lawyers don't know what standard to come up with, they just say it has to be reasonable. Well, that's what the Fourth Amendment does as well. It says searches and seizures have to be reasonable. Well, one way to make sure a search or seizure is reasonable is to refer to the second part of the Fourth Amendment, which is also up here on the screen. The second part of the Fourth Amendment says, warrants shall be based on probable cause and state with particularity the place to be searched and the persons or things to be seized. This, by the way, is the entire content of the Fourth Amendment. It's 54 words. There are roughly 500 Supreme Court cases that construe this language. From the Supreme Court alone, 500 cases that construe this language. So there's a lot going on here. What does the Fourth Amendment say? And if I were going to reduce those 500 cases to one sentence, here it is. Okay? You are now getting in this one sentence what it takes me a whole semester to teach my law students. Okay? Most searches require probable cause. What is probable cause? If you had to quantify it, for those who are mathematically oriented in this room, it's about a 50% level of certainty. There has to be a 1 out of 2 chance there'll be drugs in the house or the murder weapon in the house or some other kind of evidence will be found. And In addition, usually the police have to have a warrant, unless it's an emergency situation, unless the police don't have time to get a warrant. If they're in hot pursuit of a criminal, they don't have to get a warrant, obviously. They still need probable cause to go inside a house to look for a suspect or look for evidence, but they don't need a warrant if it's an emergency situation. So that's basically what the Fourth Amendment says. There are certainly some exceptions. There are some situations where probable cause is not required, but only something called reasonable suspicion. If probable cause is a 50% level of certainty, reasonable suspicion is something like a 30% level of certainty, a lower level of certainty. Okay? And then, obviously, it gets a lot more complicated than that, but that's the basic idea. So that's what the Fourth Amendment says. Yeah, question?
Is the question of reasonableness a question of law for the court or a question of fact for the jury?
Yeah, what the question is, who gets to decide what's reasonable and what isn't? Most of the time, it's a judicial decision, not a jury decision. If there's a damages suit brought against a police officer, saying the police officer violated the Fourth Amendment, which sometimes does happen, and we may get to that, by the way, later on, how you remedy a Fourth Amendment violation. Damages, exclusion of evidence, and so on. If we don't get to it today, we'll get to it next week for sure. If there's a suit against a police officer, then a jury decides that question. But otherwise, it's going to be a judge making the decision. Okay? So, the way the Supreme Court has construed that language you just saw on the screen is essentially the Supreme Court has reached the conclusion that none of the activity that went on in Abdullah's case is governed by that language. Supreme Court's cases have essentially concluded that none of the activity in Abdullah's case, with one exception, is governed by the Fourth Amendment. Why is that? Because the Fourth Amendment is basically stuck back in the 19th century. I guess to put it the bluntest way possible. The Supreme Court still thinks of searches in terms of what I call physical searches. That is, physical intrusions into a house, person, paper, effect. Those four things that are in the Fourth Amendment. And that's understandable if you're looking at precedent, which is what judges do, right? They look at precedent, cases from the 19th century, from the 20th century. On the other hand, we are in the 21st century now, and you think maybe they'd get off the dime on this score, but they haven't. They've basically thought about searches in terms of physical intrusions. But today, as I think Abdullah's case illustrates, what's going on in large part, or at least in a number of different kinds of cases, is what I call virtual searches. These are searches that do not require physical intrusion. They don't require going into someone's house physically. They don't require frisking a person. They don't require rifling through papers. Rather, they can be carried out from an officer's office, from a cop's office. How do they do that? They tap into a camera system and watch what a person does. Or after they put that GPS device on the car, or after they got that cell phone number, they can sit in their office and track the car, track the person, without ever leaving the precinct building. They can go through millions and even billions of records without ever leaving their office. They do it all via computer. So in other words, these searches can be carried out from a distance, and even more importantly, arguably, covertly. In other words, the person doesn't know what's happening. Okay? So I call them virtual searches. They're not physical intrusions. They're in a sense virtual because they don't involve physical intrusion. They involve investigations from a distance and often covertly. And the Supreme Court really has yet to recognize this is going on. Okay? Or, to be fair to them, maybe they recognize it's going on, but they haven't done anything about it. And you could say, well, maybe they shouldn't do anything about it. That's certainly one response to what I'm saying. And I'm going to talk about this, what the argument is for not regulating virtual searches, just regulating physical searches. But it is fair to say the Supreme Court has paid virtually no attention to virtual searches. Yeah, question and question. Yeah.
For physical searches, if you go to a house, do you need to take the document with you?
Yeah, well, that's going back to what I said before, but thanks for linking up this slide with the last one. If you go physically intrude into a house, unless it's an emergency situation, you need a warrant based on probable cause. And by the way, it has to be issued by a judge. Okay, you can't get a warrant from a prosecutor or from another cop. You have to go to a judge. The judge has to agree there's probable cause, and then you go to the house with the warrant and say, look, I have authority to search your house. In an emergency situation, you still need the probable cause, you just don't need the warrant.
But in the case of virtual searches, how would I know that somebody is...
Right, good question. Since I just said often virtual searches are covert, how would you know that it's going on? The fact remains that if virtual searches were regulated by the Fourth Amendment, the police would still need to go to a judge and convince a judge they got probable cause to do a virtual search of you. And then you're asking, how would you find out? Well, in the one area where we do regulate virtual searches, which I'm going to talk about in a second, that is electronic surveillance of your phone conversations. It's true you don't get noticed before they tap your phone. That would sort of defeat the purpose, right? By the way, we're going to be tapping you for the next month, so don't say anything criminal. You get noticed after it happens, okay? So at least you do find out about it. It's just post-notice as opposed to ex ante or pre-notice, okay? Yeah, question?
Yes. Under what circumstances can your automobile be searched if you're stopped?
Well, okay, let me hold off on that question. It's a good question. Basically, you need probable cause. You don't need a warrant, usually, but because why? Because the car is mobile, and there wouldn't be time to go back to a judge to get a warrant. But the cops still need probable cause most of the time, okay? But there's a lot more to be said about that. I just want to leave it at that right now. And there's a lot to be said about that, but I want to leave that alone for right now. Yes?
When he put GPS on the person's car and he did it secretly,
Mm-hmm.
the rest of it is public information. But
Yeah. So that's a very astute question. The distinction was made between putting the GPS on the car and then everything else that went on in Abdullah's case. And remember I said there's one exception? The Supreme Court has said the Fourth Amendment does apply. It's precisely that situation. When the GPS device is put on the car, the Supreme Court has said that's a search. Now, it only said that recently, just this last term. Until 2012, it was perfectly okay to put a GPS device on the car without worrying about the Fourth Amendment whatsoever. But the court finally got around at least to regulating that. Okay? But none of the other stuff is regulated by the Fourth Amendment. Yeah, last question, then I'm going to move on. Can the police hack into your computer? It depends on what they're getting. And so we'll talk more about that. I'm guessing a lot of these questions are anticipating what I'm going to get to, so I want to move on. And then if you continue to have a question, I'll take them, okay? Okay, so going further into what the court has said about the Fourth Amendment. The key issue for our purposes in the Fourth Amendment is what the word search means. What the word search means. Because remember what the Fourth Amendment says. The government cannot engage in unreasonable searches. So, it really is important to figure out what a search is. Now, you'd think a search is when you're looking for something, right? That's what the word search means. If you look at in the dictionary, it means when you're looking for something, examining something, looking through something. That's not what the word search means. Okay? We're lawyers. We don't like to make it obvious what a word means. We like to confuse you. So, in fact, the word search means something very different. For a long time, the word search, for Fourth Amendment purposes, meant an intrusion into one's property interests. So, yeah, if you go into someone's house and look for something, that is a search. Why? You're trespassing on a person's house. Okay? On the other hand, if it didn't involve a property interest, then it wasn't a search and the Fourth Amendment didn't apply. So let me give you an example. In the very famous case of Katz versus United States, decided back in the mid-1960s, Mr. Katz was in a phone booth. What was he doing in the phone booth? Well, the police didn't know for sure, but they thought maybe he was engaged in illegal gambling. They thought he was a bookie, and they wanted to get evidence of that. So how did they decide to get evidence about that? They put a bugging device on the phone line leading from the phone booth. And sure enough, Charlie Katz was engaged in illegal gambling. But Charlie Katz argued, after he was convicted, he said that was an illegal search. Why? The police didn't have a warrant. And you need a warrant, right? In fact, didn't even have probable cause. They had a suspicion maybe Charlie Katz was a gambler, but they didn't even have probable cause. They didn't even have a 50% level of certainty that he was engaged in illegal gambling. And so Katz said that search was illegal. What did the lower court say? Well, it's true they didn't have a warrant. It's true they didn't have probable cause, but it wasn't a search. Right? And if it's not a search, it doesn't matter whether you have warrant or probable cause or not. That's the whole point. If it's not a search, you don't have to worry about anything if you're an officer. You don't need a warrant. You don't need probable cause. You don't even need reasonable suspicion, that lower level of certainty. You don't need any justification if it's not a search. And the lower court said this isn't a search. Therefore, the police didn't need any justification. Why? Is a phone booth a house, person, paper, or effect? Is a conversation a house, person, paper, or effect? Actually, one judge said a conversation is an effect, but that's hard to argue. An effect is something like a personal property, luggage, car, that kind of thing. Plus, was there any trespass? Even more importantly, even if you could own a phone booth, which you can't, but even if you could, or even if a conversation is an effect, Was there a trespass on it? Was there physical intrusion on any kind of property? No. The bugging device was outside the phone booth. In fact, there are court cases which said if a bugging device is outside the home, there's no trespass. Now, if on the other hand, the police use what's called a spike mic, which requires intrusion into the property, in other words, the spike mic touches the wall of a house, that's a trespass, and it becomes a search all of a sudden. But if instead you use a bugging device that doesn't touch the premises, then it's not a search. That was the way search was defined prior to Katz versus United States. It was all based on property concepts. Very technical. It all depended on what property law said. But then Katz said at the Supreme Court level, the lower court said Charlie Katz lost. But at the Supreme Court level, Charlie Katz won. Because the Supreme Court changed the definition of search from one based on property to one based on privacy. And this is the way we tend to think of the Fourth Amendment today. Those of you who know this area of the law know that right now we think of the Fourth Amendment as basically a protector of privacy. And Katz versus United States is the case that established that. A search is a police action that infringes an expectation of privacy that society is prepared to recognize as reasonable. But notice, it's not just any old privacy concept. It's an expectation of privacy that society is prepared to recognize as reasonable. Now, who gets to define when an expectation of privacy is reasonable? Judges, most of the time, right? Not us. Even though it says an expectation of privacy that society is prepared to recognize as reasonable, you'd think, oh, that involves society somehow. No, it's the judges who get to decide what's reasonable. But at least it's focused on privacy as opposed to property. And so a lot of civil libertarians were very happy about Katz. They said, oh, good. This broadens the scope of the Fourth Amendment from these narrow property concepts to this broader concept of privacy. So, for instance, now we can say electronic surveillance of phone conversations and interception of email communications is, in fact, a violation of the Fourth Amendment unless you have a warrant and probable cause. Because clearly privacy is being invaded when they intercept your phone call, when they intercept your emails. And, in fact, that is true. Since Katz, the court has said that if the police intercept the content of your phone conversations or the content of your emails, in other words, they intercept the content of your communications, then the Fourth Amendment's implicated. But go back to the Abdullah case. The police didn't do any of that in Abdullah's case, right? They didn't intercept any of his conversations over the phone. They didn't intercept any of his the content of any of his emails. They did find out who he was calling and who he was receiving calls from. They got phone numbers. And they did find out where he was spending money and where he was charging his credit card. But they didn't find out the content of any of his conversations. So nothing in Abdullah's case implicates the Fourth Amendment after Katz. And I want to explain why by talking about 4 Supreme Court doctrines. But I'll take a couple of questions before I do. Yeah.
Well, with respect to the cameras filming inside of his house, surely that exceeds what society recognizes.
Wait till you hear what I have to say. Okay? Okay? So, because that's wrong. Okay? Yeah.
Was the Katz case relied on in Roe versus Wade in 1973?
No. It cited it, but the question is, did Katz rely on Roe versus Wade? As you all know, that's the case that had to do with abortion. And certainly the court talked about privacy, but that's a different genre of privacy, so it didn't really focus on Roe versus Wade kinds of concepts. And of course, Roe versus Wade came after Katz, so it couldn't have actually cited it. But it didn't even really get into that area of privacy. It got into different areas of privacy having to do with government intrusion for the purpose of getting evidence. So how did the court end up restricting the definition of search so significantly, despite the fact that searches now are defined in terms of privacy? These 4 doctrines are the way the court's done it. The knowing exposure doctrine, the general public use doctrine, the contraband specific doctrine, and the assumption of risk doctrine. I'm going to talk about all 4 of these doctrines without getting too technical, because I know you don't want to hear a whole bunch of technical stuff. But I think you'll find it very interesting the way the court analyzes when we have expectations of privacy. And these 4 doctrines are the way the court does it. The first doctrine is simply this. What a person knowingly exposes to the public, even in his own home or office, is not a subject of Fourth Amendment protection. What you knowingly expose to the public, even if you're in your home or your office, is not private. Okay? And Katz itself said this. This is the case that supposedly expanded the scope of the Fourth Amendment. This comes from Katz itself. So what has happened since Katz? Well, the current Supreme Court, which many of you know is a relatively conservative court, relatively prosecution-oriented, relatively law enforcement-oriented, has taken this idea and run with it. So you get a case like Knotts versus United States. This is a case where the police put a beeper on the defendant's car. Actually, they put a beeper in a can of ether that the defendant purchased and then put in his car. And they followed that car for about an hour using the beeper. And Knotts said this was a search. It's certainly not reasonable to expect the government's going to use a beeper to track you for an hour or more as you travel around the streets. But the court said, no, you're knowingly exposing yourself, if I may use that phrase, it's a little risque, but nonetheless, you're knowingly exposing yourself as you travel around the public thoroughfares. This is what the court said. A person traveling in an automobile on public thoroughfares has no reasonable expectation of privacy in his movements from one place to another, period. So when you're out in public, you have no privacy. That's what Knotts says. Okay? You have no privacy in public. The court expanded that in what are called the flyover cases. These are cases that came down in the 1980s. Basically what the court said is, in fact, police can spy on you not only when you're in public, but also even when you're on private property, so long as it's what's called the curtilage of your home. Okay, what's the curtilage? This is something you can impress your friends with if you don't know already. Curtilage is the area immediately surrounding your house. It's an old property term. Okay, the curtilage of your house, as the name sort of implies, is immediately around, it's your backyard basically, your backyard and your front yard. Okay, what you put a fence around if you could afford a fence. Okay, so even spying on the curtilage is not a search, does not infringe expectations of privacy if it's done from the air. Now, if you intrude on the curtilage, that might be a different story. If you physically intrude on the curtilage, maybe that's a search. But if you're in a helicopter 200 yards above the curtilage, it's not a search. Okay? Why not? Well, here's the answer. Because any member of the public in navigable airspace could have seen what the police see. Any member of the public could rent a helicopter and fly 200 yards over someone's backyard, right? True? So you're knowingly exposing to the public what's going on in your backyard by having a backyard without a roof over it. Okay? If you had a roof, you wouldn't be knowingly exposing what's going on in your backyard. But since you don't, I assume, you're knowingly exposing yourself to any member of the public, and therefore the police can do it without any justification whatsoever, right? It's not a search. You don't need any justification whatsoever. So what do the police do? They fly over lots of backyards. One of my favorite lines in a Supreme Court case came in one of these flyover cases, because in one of these flyover cases, the defendant did actually have a fence around his backyard, a 10-foot high fence, opaque fence. And he said, well, at least in that situation, I have an expectation of privacy, right? I've created an expectation of privacy by building this fence around my backyard. And Chief Justice Berger said, no, you didn't, because anybody in a double-decker bus could have looked over the fence. He said it. I'm not making this up. Okay? Apparently, he had just returned from a trip to London. He said, well, you know, I mean, anything could happen. So even that defendant lost. No expectation of privacy because, after all, there are double-decker buses somewhere. Okay? So that's one application of the known exposure doctrine. Now, there is this one exception. And this is the case that came down just this last term. The court did say that if the police track you by using a device they put on your property, that is your car, then that is a search. In Jones versus United States, the police put a GPS device on Jones's car and tracked him for 28 days. 28 days. And the court said that was a search because they effected the search through a trespass. Now, it's a very trivial trespass, and I can tell you as someone who knows property law that that would not be an actionable trespass. Okay, you wouldn't be able to get damages if someone put something on your car bumper. But Justice Scalia, wanting to show he is a liberal in disguise, nonetheless said that this is a trespass, and therefore the Fourth Amendment is implicated. So that's the one exception. Remember in Abdullah's case, Officer Jones did put that GPS device on the bumper. That now would be a search. What does that mean? You need some kind of justification to do it. You can't just do it willy-nilly. Now, do you need probable cause and a warrant? I said that's usually what you need, but it's not clear from Jones. Jones doesn't say what you need. You need some justification, but we don't know yet what that justification has to be. But the important point is it is a search if there's a trespass. But how do most police track people these days? They don't use GPS devices. That's old news now. Rarely do you use a GPS device to track them. Use their cell phone. Under federal law, your cell phone has to be sophisticated enough to enable you to be tracked within 15 feet of your location. So every modern cell phone has that capacity. Or put it this way, law enforcement has the capacity to track you within 15 feet of your location if you have a modern cell phone. And tracking with cell phones, does that involve a trespass? No. No trespass at all. Unless, one lawyer made this argument, unless you trespass on the electronic particles that are being emitted from your cell phone. That argument didn't win, but hey, what the hell? If trespass is going to be the way we look at this, then you, as a lawyer, you make the argument you think will win. It's not going to win, and since it won't win, that kind of tracking does not infringe the Fourth Amendment, does not implicate the Fourth Amendment, need no justification whatsoever to track with a cell phone. In fact, our own Sixth Circuit, the circuit court that applies here, held that just 3 weeks ago. That cell phone tracking is not a search. It held that after Jones. It distinguished Jones from cell phone tracking. Yeah.
If someone has been convicted and the definition of search changes, can you use that for a defense?
Okay, so the question is, can you apply Jones retroactively? Yeah. Basically, no. Good. I mean, there are some issues about that, but basically, these kinds of decisions, if they ever are pro-defendant, and of course they rarely are these days, but if you do have a pro-defendant decision that comes down the pike like Jones, virtually never is that applied retroactively. Okay, so governments have taken the NOTS idea, the knowing exposure idea, and run with it. So for instance, you have, as I alluded to a little bit earlier, camera systems in a large number of cities. In fact, the federal government is helping to fund this. In Chicago, there are 2,400 cameras that were all instituted as under a program called Virtual Shield. And these cameras have night vision capacity. They have zoom capacity, so you can zoom in on what a person's reading. Some of them have facial recognition capacity, which you may have heard of. It's a computerized program that allows police to see if a face on the street correlates with the face in their files, in their mug files, to see if a criminal is walking the streets. New York City, back in 2006, had 4,200 cameras just in Lower Manhattan. Just in Lower Manhattan. Today, the number is about double. Though I should add that that number includes private as well as public cameras. So that's not all public CCTV. It's also private cameras in stores. In Chicago, these cameras are all linked in with a $23 million command center. So in other words, police can monitor all these cameras 24/7 with facial recognition technology. Again, they have night vision and zoom capacity. So basically, if you're in Chicago, New York City, you're being watched all the time if you're in public. You're on camera. So smile. Okay? The knowing exposure doctrine goes further than that, though, because it also suggests if you're in public, the police can use not only cameras that you know about, because there's a sign saying CCTV in the vicinity, or you can see the cameras up on the building and the telephone pole. It also allows public surveillance using satellite cameras, or, you may have heard recently, drone cameras. The drones that used to be in Afghanistan are now coming over here. They're being equipped with cameras. The federal government predicts that in the next 20 years there'll be 30,000 drones. 30,000 drones flying over this country. They have camera capacity. Some of them have camera capacity that allows the government to pick up your license plate number. So they're pretty good cameras. Okay? Does any of this implicate the Fourth Amendment? No. Why? It's in public. Right? If you're in public, you're knowingly exposing yourself to CCTV and to drone cameras and to satellite cameras. So that's the knowing exposure doctrine, but I'm still not through. Okay? Because as I said, you can track using cell phones, no problem. And another development I have not alluded to yet is something called RFID, radio frequency identification devices. Some of you are nodding your head, you've heard about this. Virtually anything can be outfitted with an RFID. What does it do? It sends out a pulse, which can be tracked. Now, some RFIDs are not very good. You have to be within 200 yards of them in order to pick up the signal. Others are very good, and you can track over a much longer distance. So this is another way of tracking someone. Now, remember, Jones, if you have to trespass on someone's property to fixate this RFID, then you've got a problem as far as the Fourth Amendment is concerned. Okay? So in other words, if the police put an RFID on your luggage, that would violate Jones. There need to be some justification. But what if the police do this? What if they put an RFID on luggage before you buy it? I mean, that's what they did in Knott's. They put that beeper in the ether can before the defendant bought it. There's no trespass there, okay? Because the RFD is put on that property before it becomes your property. So the trespass did not occur while it was your property. So what's the moral of that lesson for the police? Put an RFD on everything. Now, they're not doing that yet, but they could. These are pretty cheap. Put it on everything, and then activate it when you want to activate it. If they suspect someone, you activate it and follow their luggage around. And there's no violation of Jones because the RFID was put on the luggage before you bought it. Yeah?
Shouldn't the merchant that is selling the luggage, should that
It's the merchant's property, absolutely. And so the merchant can say, you can't do that, but what merchant's going to say that? Right? Unless maybe he belongs to the ACLU. Right? He's going to say, don't put that RFID on my luggage.
But he's not obligated to tell the customer.
Oh, no, certainly not. And the government will probably say, don't tell the customer, right? But I'm telling you right now it could happen, so now you know. Okay? And by the way, the analog to this has already happened with respect to cars. In California, there's something called an intelligent transportation vehicle system. Intelligent transportation vehicle system. What does this do? It requires manufacturers to put transponders in everyone's car that sends out a signal as to where everyone is. And this data can be accumulated not just in real time. In other words, not just while you're driving, but a record can be kept of this. So if the police want to find out where you've been the last month, they can do this using the transponder. Why doesn't this violate Jones? The transponder is put in the car before you buy it. So it's not a violation of Jones. Yeah?
But does the activation make that a specific change?
Does the what make it a...
If it's inactive on the luggage and the police activate...
Ah, okay. So the question is, what if it's put in the luggage before you buy it, or put in the car before you buy it, not activated, presumably, because that'd be wasting energy, then it gets activated. That's what happens with a cell phone, right? They don't actually start acquiring the signals unless and until it's turned on.
But it is specifically directed to a...
Okay, I think, as a lawyer, I would argue that. In other words, if the police have to be the ones to activate the signal, that somehow becomes a search. I doubt Scalia would buy that, but it's an argument that could be made. So good point, yeah.
Okay, when I bought our car, we put low jack on it.
Low jack.
So what you're saying is that if the police decided to follow me around, I've just given them an opportunity to do that.
Yeah,
Because I've already put the system on there.
and you consented to putting the low jack on in your car.
Okay.
Interesting question. Again, maybe you can make an argument that if you put a device on your car for one purpose, it shouldn't be usable for another purpose. But you can tell from the cell phone tracking cases that doesn't work, right? Because why do you buy a cell phone? Not so the police can track you, right? You buy it presumably so you can do email, get on Facebook, et cetera, and yet that argument, and yet it's still possible to track you with your cell phone. Yes?
So, with all this surveillance,
I'm not even close to done, by the way, with all this surveillance. We're just on the first doctrine. I got 3 more to go.
and maybe you'll get to
Uh-huh.
with all this surveillance, has it increased arrests and...
Yeah, good question. How effective is this stuff? On closed-circuit TV, there are a lot of studies, mostly out of the United Kingdom, because there are over 3 million cameras in the United Kingdom. They've had cameras for a long time. It's absolutely true you can't go anywhere in the United Kingdom in an urban area without being on camera, from the time you leave your house to the time you get back to it. They have found that when you have good cameras, in other words, modern digital cameras as opposed to those old fuzzy things, crime can be reduced by 4 to 6%. 4 to 6%. That's it. Okay? And a lot of times that crime gets displaced. And also, as criminals learn about where cameras are, they wear masks, they commit the crimes in areas where the cameras don't focus. You can't have a camera on every square inch, right? So there are certain foci that are not covered by cameras. There are also crimes that are caught on camera, but they're impulsive crimes. So they're not going to deter crimes. Now, it might help you figure out who committed the crime in that situation, but the camera doesn't prevent the crime. Why? Because it's an impulse. It's an impulse kind of crime. But crime has been reduced by 4 to 6%. And maybe it's worth it then. On the other hand, these cameras cost an awful lot of money. So, and by the way, it prevents very few violent crimes. Okay? The violent crime rate has not gone down significantly, but there has been a reduction in property crime. Maybe it's worth it, maybe it isn't. One study found that cameras in a private store as opposed to in a public space. Private store, yes, it did prevent some degree of shoplifting, but actually the cost of the cameras was more than the theft that it prevented. So I'm not saying that applies to everything, but that's what one study found. So arguably that's the kind of analysis legislators should be engaging in before they go hook, line, and sinker into this kind of surveillance. So it's a good question, but the bottom line answer is we don't really have good information yet. A lot of this stuff has just started in the last 3 or 4 years, and we don't have real good information on how effective all these kinds of surveillance are. Yeah, go ahead.
On the news last night, they were showing that the YMCA has now put tracking devices in their towels because they were losing so many
There you go.
with people walking out of the Y. It was costing them $30,000 a year to replace lost towels. So they just started putting.
So maybe that's cost effective. It depends upon how much the RFID costs, but obviously that organization decided it is cost effective. Just make sure that you wash that towel when they come and get it from you.
A security company that I know of here in town recently advised a customer to get 2 real cameras and 5 fake cameras.
Yeah, the theory behind the fake cameras is obviously that'll deter without costing you much money whatsoever. Again, you've heard what the data is with respect to camera surveillance, even with real cameras, 4 to 6% reduction in crime. So again, you can add that to the cost calculus. But it would be cheaper, obviously, if you believe that cameras do deter. I'm suggesting they don't deter as much as we might think, given the data. 2 last questions, and then I want to move on. Yes?
Back to your suitcases being impregnated with the RFD. If you ask that it be removed, or ask that it is contained in the suitcase, and you were told yes, and yes, it can be removed, you purchase the suitcase and then commit a crime and find out that it has not been disabled.
They lied to you? Yeah. Good question. I don't know for sure the answer to that. I can tell you the predicate is you certainly have the right to demand there not be an RFID in your luggage. And if enough people do that, what will happen? There'll be stores in which the owners do in fact refuse to allow this to happen because they want people to buy their luggage. Okay? But assuming that doesn't happen, and in other words, the store owner does put the RFID in and lies to you about it, could you later say that's a violation of the Fourth Amendment? I think you've got a good argument, but wait till I get to the fourth doctrine, and you'll see that, in fact, lying doesn't really count for that much. Okay, last question, then I want to move on.
It's actually not a question. I would just say that there's an RFID tag in almost every library book.
Oh, okay.
Used for inventory control in most orders, so they're already on everything.
Yeah, so they're already on a lot of things. And again, they can be used to track. Okay? And you could see how the police might want to track a book, especially if it's a book that tells you how to make bombs. Okay, so let's say now that the police want to look inside your house. We're no longer talking about looking at public activity, where you can see an argument, hey, any member of the public could see you, therefore the police ought to be able to see you. Now we're talking about looking inside your house. This goes back to your question a little bit earlier. Even that's okay. If what the police are using is technology that's in general public use. Okay, so in Dow Chemical, case back in the 1980s, the court said that even a $22,000 map-making camera is in general public use. In other words, any old person can go buy one of these things and use it. Therefore, you don't have any expectation of privacy with respect to the use of these things. Okay? Now, it happened that Dow Chemical involved use of this camera to look at curtilage. Remember? A test. What does curtilage mean? Very good. Okay. So you could say, if you're a lawyer, you say Dow Chemical only applies to use of sophisticated technology in general public use that's looking at curtilage, not inside the home. And if you're a lawyer, you'd be, therefore, if you're making that argument, you'd be gratified by this case, the Kylo case, which involved use of what's called a thermal imaging device to look inside a home. What does a thermal imaging device do? It calculates heat differentials inside the home. And that allows the police sometimes to figure out what's going on inside a home. In Kylo itself, they were able to figure out there were some very high-intensity Klieg lights inside the home. What does that suggest? Marijuana. You're growing marijuana. Why would you have high-intensity Klieg lights in your house if you weren't growing drugs? Well, actually, some defense attorneys would answer that. There are lots of things you could be doing with those Klieg lights, but nonetheless, the police, after getting this thermal imaging reading, went to a magistrate. The magistrate said that gives you probable cause to go search the house, and the police did. The argument by the defendant was, though, yeah, they had a warrant when they searched my house, but they didn't have a warrant when they used that thermal imaging device to see the heat differentials inside my house. And that was a search. The lower court said, no, it isn't a search. Why? Thermal imaging device, general public use. Okay, lots of people have thermal imaging devices. Yeah. Well, you know, after Dow Chemical, if a $22,000 map-making camera is in general public use, then hey, thermal imaging devices only cost half of that at the time of Kylo. So it wasn't a totally off-the-wall argument, but the Supreme Court drew a line here. It said if you're looking inside a house with a thermal imaging device, that is a search. You need probable cause and a warrant to do it. Why? Because a thermal imaging device is not in general public use. It's not something that the average member of the public has. And therefore, you can't use it to look inside the house. So that sounded like it's a blow for civil libertarians who want the Fourth Amendment to be expansive. But of course, there still is this general public use doctrine. So what does that mean? You can use binoculars to look inside a house. Binoculars are clearly in general public use. For that matter, you can use a telescope. I've been to Walmart. In fact, I wrote an article called The Walmart Test. Okay, when is something in general public use? When you can buy it at Walmart. If you can buy it at Walmart, anybody could own it, right? This camera has a 200 magnification, this telescope has a 200 magnification capacity. So it's very powerful, but I would argue if I were the prosecutor, it's in general public use. Anybody could buy this for just, actually, it's now more like $100. But it was at one time $50. So, if I'm the prosecutor, I say general public use, and you can use that to look inside someone's house if you want to. How about the Startron, using Abdullah's case? No problem. You can buy it on eBay for less than $4,000. So that magnification device with night vision capacity, if I'm the prosecutor, argue that comes under the general public use exception announced in Dow Chemical and Kylo. Even thermal imaging devices today you can get for $1,500. Maybe you can't get it at Walmart, I haven't checked, but you can get it relatively cheaply. So maybe thermal imaging devices were not in general public use back in 2001 when Kylo was decided, but if I'm the prosecutor, I say, hey, things change. Now even thermal imaging devices are in general public use. Okay, so that's doctrine number 2. But I'm not finished with that doctrine. Kylo, well actually I am finished with that doctrine, but I want to go back to something else Kylo said. Kylo said that even if the device is not in general public use, like what would be an example of that? A satellite camera. Presumably that's not in general public use. But you could say with Google Earth maybe it is. That's an interesting issue. But anyway, assuming a drone camera or a satellite camera is not in general public use, it can still be used to look inside a house if all it does is replicate what a cop could see with the naked eye from a public vantage point. You understand that point? So in other words, if a cop could see inside your house from a sidewalk near your house, a satellite camera or drone camera can see the same thing without implicating the Fourth Amendment at all. Okay? Now, why wouldn't you use a naked eye observation by a cop instead of an expensive satellite camera? Well, maybe because if the cop's standing on the sidewalk, you're going to see him and draw your curtains. The advantage of a satellite camera is you don't, the suspect doesn't know that he or she's being observed. But Kylo says, nonetheless, that's okay, so long as a cop could theoretically have seen what the drone camera or satellite camera sees with the naked eye from a public vantage point. So basically what these pictures represent is you can use drone cameras, satellite cameras to look inside a house if a cop could see the same thing with the naked eye from the sidewalk. We're not through with all the surveillance devices. Now I'm in doctrine number 3. Let's say you're wise to all this and you basically make your house a fort. Okay? You draw all of your curtains. You have very, very thick curtains. So nothing can be seen through your windows when you have those curtains drawn. And your walls are very, very, very thick, so no thermal imaging device can see through them. Okay? There's still another doctrine to think about. I call it the contraband-specific doctrine. It was announced in the Place case back in the 1980s. It involved a dog sniff. You've all seen this, or at least heard of it. Dogs sniffing luggage to see if there are drugs in it. The court said this is not a search. Why? All the dog alerts to is the presence of contraband, the presence of drugs. It doesn't alert to anything that has significant privacy value connected with it. The dog doesn't alert to dirty underwear or towels or anything else. It only alerts to marijuana. If all the dog is alerting to is contraband, there's nothing of legitimate privacy significance that the search is revealing. So the court said this isn't a search. Even though it is looking for something or sniffing for something, it's not a search because only contraband is discovered as a result of it. Well, dogs are probably the only real example we have of contraband-specific searches right now, or contraband-specific intrusions. For instance, X-rays reveal more than just contraband, right? So what you see here would not be a contraband-specific search. Why? Obviously, more is being revealed than just contraband. But I show this picture to you because this is what happens to you when you go to airports these days. Okay? There are devices that do this at some airports, including here in Nashville. And the Raytheon device that I described at the beginning, remember the Raytheon electromagnetic pulse scanner? That's being developed by Raytheon, and it will be able just to discover weapons and bombs. It will be contraband specific. It will not be like this, revealing a whole bunch of stuff. It will reveal only weapons and bombs. And under place, that's perfectly okay, even if they beam it at your house with your closed curtains. Okay? So long as all that's discovered is contraband, then it's permissible. Now, of course, there's a question. In Tennessee, as well as 27 other states, it's okay to have a concealed weapon. It's legitimate. So if they see a weapon using the Raytheon device, is that a search or isn't it? And that hasn't been settled yet. If I'm a prosecutor, I say, hey, if it's a weapon, I got to check it out. So long as my device only detects weapons and nothing else, I should be able to do it without worrying about the Fourth Amendment. But of course, if you're a defense attorney, you say it depends on whether you're in a state where you can have concealed weapons and where you can't. So I don't know how that's going to come out. Yeah.
Plastic bombs inserted in the human anatomy.
There are devices that they're trying to develop. The question is, are there devices yet that can discern whether you've got plastique on your person or in your person, as opposed to something metallic? And that's a lot harder to discern. These devices can do it, for sure. But they're not contraband specific because they reveal a whole bunch of other stuff, too. There is a case that's going to be decided this term involving another dog sniff, this time a dog sniff of a house as opposed to luggage. And to do this dog sniff of the house, they had to go on the person's curtilage. Okay? They had, see how much you're learning here? Curtilage. They had to go on the defendant's curtilage. So, what should the court decide? It is a dog sniff. Place says that's not a search. But what would be the defense argument? To trespass on private property. And you cite Jones, right? You cite Jones for the proposition that if you need a trespass in order to carry out the search, then it is a search for Fourth Amendment purposes. What would be the prosecution response? A lot of people have sidewalks leading right up to their front door. That invites people in. Okay? No, I'm serious. This is a property law concept. If the court's going to go with property, this is an argument I make as a prosecutor. Granted, your curtilage is your private property, but if the police stay on the sidewalk and the porch, then arguably that's private property onto which you invite people. And basically you consent to have strangers come on your property with the sidewalk and a porch. Now, if they go all the way around the house to the backyard, that's a different story. Yeah.
Church. I was getting married. There were 2 helicopters hovering by.
Mm-hmm.
They literally ruined our I-dos. A van pulls up, says floral van. The door flies open. Photographers rush in.
Mm-hmm.
Hospital. I'm in a room, and
So all of that could be a privacy invasion, and you could sue people for it. Probably lose, but you could. Since, you know, if you've got celebrity status, you're going to lose. But it has nothing to do with the Fourth Amendment, of course. That's what the Fourth Amendment has to do with government action, when the government engages. You could argue in a damages suit against the private news companies or whatever was involved in this helicopter and van surveillance. You could sue them on a trespass doctrine, but I think the better way to go is invasion of privacy. There's a tort for that. It's pretty hard to win those. Okay, so I've talked about 3 doctrines: knowing exposure, general public use, and contraband specific. I'm not even close to finished with what the government can do. I'm getting to the 4th and final doctrine. This is the most powerful exception to the idea that privacy ought to govern when there's a search under the 4th Amendment. What's the assumption of risk doctrine? Here it is in one sentence. It comes from a 1976 case. An individual takes the risk in revealing his affairs to another that the information will be conveyed by that person to the government. And here's the part that's relevant to the deception point we were talking about earlier. Even if the information revealed on the assumption it will be used only for a limited purpose and the confidence placed in the third party will not be betrayed. What does that mean? You give something to another person, you assume the risk that person will turn around and fink you out to the government. And therefore, you have no expectation of privacy. You've exposed that information to a third party. As soon as you do that, you lose all expectation of privacy with respect to that, what that third party might do. Now, this might make some sense, a civil libertarian would argue, if the third party is a person. Why? If you give information to a person, even if it's your friend, that friend has an autonomy interest. He or she should be able to do whatever they want with that information. If they want to give it to the government, they should be able to. They have an autonomy interest that might trump your privacy interest. But Miller involved a bank. The third party in Miller was a bank. And the question in Miller was, can the police get the information from your bank about your transactions without worrying about the Fourth Amendment? And Miller said yes. Why? You gave that information to the bank. You assume the risk. The bank will turn around and give it to the government. Assumption of risk. This is what I call an institutional third party case. Okay? The third party is not a person, but an institution, a bank. And the court said you assume the risk that when you give information to a bank, it's going to turn around and give it to the government. They said the same thing with phone records. In Smith, they got the defendant's phone records. They found out everybody he called and everybody got calls from. He said, you can't do that. That violates my privacy. The court said, no, it doesn't. It doesn't violate privacy as we define privacy. Remember, courts get to define what's the reasonable expectation of privacy, not us. And what the court said is, you assume the risk that when you dial a phone number, the phone company will record that number and hand it over to the government. And the court also said you should know that that's what happens. And if you don't, you should know. And now, of course, all of you do know, so you can no longer argue you didn't know. Okay? But I know you knew that already. Your phone number is recorded by the phone company, not only the ones you dial, but the ones you get phone numbers from. By the way, same thing for email. Every email address you send something to, every email address you receive something from, your internet service provider has a log of all of that, and Smith applies to that. You have no expectation of privacy in that information. Now, it's not the content of your email, it's not the content of your phone calls, but the government can discover a whole lot just by looking at who you call, who you send emails to, who you receive phone calls from, who you receive emails from. Okay? So it's very useful information, not denying that. The civil libertarian there would say, but the government ought to have some justification before they get that information, and the court says, no, they don't. They don't need any justification. It's assumption of risk. Yeah? Oh, yeah. I mean, well, you're asking about the FBI. Certainly it applies to the FBI. NSA, the National Security Agency, though I like to call it no such agency. I was on a task force for 5 years dealing with surveillance issues, and there were 2 representatives from the NSA at all of our meetings, and not once did they say a single word. All they did was write down stuff. It was very scary, very intimidating. They don't like to talk about what they do. My guess is they pay no attention. Even if the court reversed all of these decisions and said, all of this violates privacy, the NSA wouldn't care. And the NSA would do whatever it wants to do. Why? On national security grounds. And they might actually win that argument if it ever got to court. But of course it never will get to court because we don't know what they're doing. Yeah. Okay, so the question is, what if you tell your doctor information or your lawyer information? Well, let me get to that by going to the next 2 slides. This assumption of risk doctrine is incredibly powerful because of these 2 pieces of information. The world's data about us, personal information, has doubled every year, and computing power is increasing even faster. So what does this mean? All of this stuff in third-party records is very easily accessible if you know how to do it, okay? Including this kind of third-party information. Store receipts, tax records, bank records, and hospital charts. If you think about it, what you give to your doctor, you're giving information to a third party. You assume the risk that doctor will turn around and give it to the government. Now, in that one case, some states have said, we're not going to follow Miller. That's going too far. Banks, maybe. Phone companies, maybe. But doctors, no way. So what state courts have done, some state courts, not many, but some have said, based on our state constitution, we are going to say hospital records are protected with the warrant requirement. We're not going to follow the assumption of risk third-party Miller doctrine. Okay? So you can make distinctions. It's just the point I'm making is right now, as far as the Supreme Court's concerned, there are no distinctions. Okay? Yeah?
What if your doctor records go to the insurance company?
What if the doctor records go to the insurance company? What Miller says is if you voluntarily convey information to a third party, your host,
I mean,
as far as the Fourth Amendment is
states
concerned.
that have prohibited that.
What?
With the states who have prohibited the Miller Rule. In other words,
Oh, yeah. The states would still protect the states that have refused to impose Miller would also protect against insurance records, medical records going to insurance companies being revealed without a warrant. So you have protection in those states, but again, there are not very many of them. And yeah, last question, I want to move on.
I thought that's why we passed HIPAA.
Yeah, okay, so the question is, what about HIPAA? What does HIPAA say? If the government asks for medical records, it gets them. That's what it says. HIPAA protects your privacy, medical privacy in all sorts of ways, but not from the government. Okay, now usually the government has to get some kind of order, some kind of court order. It doesn't have to be a warrant. It can be a subpoena. You've all heard that word, right? What's a subpoena? It's basically a prosecutor saying, I think this information is relevant to whatever I'm doing. It's not probable cause. It's not even reasonable suspicion. It's relevance. Almost anything's relevant to a criminal investigation. I'm serious about that. Relevance is a very low standard. You've all heard, or maybe you've heard the phrase that when prosecutors go to a grand jury to get an indictment, they can indict a ham sandwich. What is that meant to imply? It's very easy to indict people. Why is it easy to indict people? Because all you need to show is you got some relevant information suggesting this person's up to no good. So HIPAA does require a subpoena most of the time, but it's very easy to get a subpoena. Basically, the government can get medical information almost any time they want it. Not any time they want it, but almost any time under HIPAA. And under the Fourth Amendment, they don't need any justification. And that's the point I'm really trying to emphasize. If they got rid of HIPAA, the Constitution would provide no protection whatsoever vis-a-vis government investigation. So what is the government doing under the authority of the third-party doctrine? It's developing what some people call data mining programs. Have you heard this phrase before? Data mining. So you have a program like Reveal, which is run by the federal government. It combines 16 different government databases, including the database from the Social Security Administration and the database from the IRS. And it can go through all 16 databases like that, looking for personal information about particular individuals. There's a program called Matrix. One thing you'll notice is that the government's not really good at PR when it names these things. You probably don't want to call the surveillance program Reveal. I mean, it's just not good PR. Call it, I don't know, call it getting information, call it data mining. But Reveal, and then we've got Matrix, which has got its own problems, given what Hollywood's done with the word. But this program was something the states could use to access tens of billions of records in seconds. Tens of billions. I'm not talking millions. Tens of billions of records in seconds. And then we got the most famous one. Talk about bad PR. This is what Admiral Poindexter called the big data mining program that came into being after 9/11. Total information awareness. Okay, this didn't go over well, and in fact was defunded in 2003. Even Republicans voted against it, even after they changed the name to Terrorism Information Awareness. Okay, why was it voted against? Well, you probably can't see, but if you look on the left-hand side, that very small print on the left-hand side, what TIA was meant to do was access financial, educational, travel, medical, even veterinarian records. You know, your dog might be up to no good. Transportation records, housing records, critical resource records, government records, and communication records. That's what that left-hand side says. Access all that information, and the Constitution doesn't prohibit any of that. It's all third-party information. And then apply algorithms meant to identify who the terrorists might be. Going back to your question about effectiveness, to our knowledge, they've never found a terrorist using this, but we don't know. I mean, they may have. They just aren't telling us, okay? I'm willing to believe they may have found one or two, but how many people's records have they gone through in order to find out about those one or two terrorists? We don't know. So as I said, all of this was defunded in 2003. I think the main reason was this. This was Admiral Poindexter's icon for TIA, and he was very proud of it. What does it say? Total information, well, it says Information Awareness Office. It's got this pyramid with the all-seeing eye looking out over the globe. And if you know Latin, that Latin there is knowledge is power. Well, that scared, as I said, even Republicans. They said, we don't want anything to do with this. We're going to get rid of this. And they did. However, the main point is that we still have it. There are now 73 so-called fusion centers in the country today. What is a fusion center? It's meant to do exactly what TIA does. It collects information from lots of sources and fuses it together. And there's 73, at least 73, that we know of, around the country doing this, including one in Nashville.
Is there a problem
Yeah, government operated, yeah. And they're used by law enforcement. Okay, so I'm now done with what surveillance is doing. I want to quickly go into whether we should care. Yeah.
Is there any connection with Google to all this?
Well, yes, the connection is that the police can use Google just like we can. And of course, what the government argues is, hey, if we can use Google, why shouldn't the police be able to use Google?
I meant tracking the searches I do on Google.
Yes, so, yeah, okay, I'm sorry, yeah. The police can use Google like we do, and they also can use the police can get access to our cookies. That is where we've gone, the URLs we've visited. Even if there are some restrictions, even just knowing the URLs of places you visited tells the police a whole lot about what you're up to. And the police use that all the time, and again, it's not restricted at all by the Fourth Amendment. Okay? So the question is, so what? I tell some people about all this, and they say, I don't care. I've got nothing to hide. I don't care if the government's doing all this surveillance. I'm not guilty. Take Abdullah. If it turns out he is a terrorist, great. You know, if we find out from all this virtual searching he is a terrorist, we've got a big plus in the win column. Even if it turns out he's only an illegal immigrant, we've done something useful. And if it turns out he's innocent, he'll probably never know it. He'll probably never know the surveillance took place, right? It's all covert. So who cares? I think that's a perfectly plausible response to everything I've been saying. Okay? So let me talk about why might still need to worry about it. I don't know how easy this is to see. This is the result of a study I did along with 2 other people, asking people how intrusive they thought various kinds of police actions were. And the actions you see in white are physical intrusions. Remember that distinction I made between physical searches and virtual searches? The ones you see in white are physical intrusions. The Supreme Court has said a roadblock is a search and a seizure that requires some kind of suspicion. You know, when they stop you on the road, stop you in your car, that's governed by the Fourth Amendment, and you need either a localized problem like drunk driving, or you need some kind of suspicion that the person you're stopping is up to no good. Number 4, a frisk, you all know what that is. It's a pat-down. That's also governed by the Fourth Amendment and requires reasonable suspicion. Remember that level of certainty below probable cause? That requires, a frisk requires reasonable suspicion. Number 7, search of a car. Going back to the question that was asked earlier, you need probable cause for search of a car. Why? It's seen as more intrusive than a frisk. A frisk is just a pat-down. Search of a car is seen as more intrusive, so you need that 50% level of certainty. And then number 10, search of a bedroom, you need probable cause and a warrant, unless there's an emergency situation, because that's the most intrusive kind of thing. Okay, so what do people think about virtual searches in terms of intrusiveness? Well, it turns out numbers 8 and 9, accessing internet service provider logs, like we talked about a second ago, perusing bank records, they see that as at least as intrusive as search of a car, and almost as intrusive as search of a bedroom. So to the I got nothing to hide argument, the argument can be made, hey, this virtual searching can be very intrusive as searching a car. So maybe we need probable cause for that. How about putting a beeper on a car, tracking a car? People saw that as almost as intrusive as a frisk. So if a frisk requires reasonable suspicion, maybe tracking should require reasonable suspicion. And then how about public camera surveillance? People saw this as more intrusive than a roadblock. And as I just got through saying, a roadblock is governed by the Fourth Amendment. So why wouldn't camera surveillance be governed by the Fourth Amendment if we're worried about relative intrusiveness? It's also the case that virtual searches can be abused, just like physical searches can be abused. So you all know about J. Edgar Hoover accumulating dossiers on his enemies. That was a record search kind of investigation he was doing. Back in the old days when we didn't have computers. John Mitchell, same thing. Attorney General John Mitchell accumulated lots of information about anti-war protesters during the Vietnam era, and that was seen as an abuse. More recently, you get these kinds of headlines using virtual searches. And most prominently, you've got this headline. This headline refers to the FBI's use of national security letters. Has anybody heard of national security letters? These are letters that can be issued by a special agent. What does the term special agent mean? It means any FBI agent. I know it sounds special, but basically it's any FBI agent. Okay? Doesn't have to be a magistrate, doesn't have to be a judge, doesn't have to even be a prosecutor. It's a special agent that issues national security letters. Now there is a limitation on national security letters. They have to be aimed at getting information about national security. Okay? But if you can convince yourself as a special agent that what you're going after is national security related information, You can issue one of these letters, and it authorizes getting financial records, bank records, credit card records, travel records, lots and lots of records. Not the hospital records, but a lot of other kinds of records. What this headline suggests is this authority has been abused, and it was. Okay? An independent audit indicated it was being abused. So there is this possible problem with virtual searches, that they can be abused. Other possible problems, what's called mission creep. Okay, even if the government's acting in good faith, you can have the development that is well known in many other areas as well, where a program starts out focused on one thing and then slowly but surely starts expanding to other areas. So for instance, total information awareness, it was a terrorist program, right? That's what it was all about. That's what Admiral Poindexter wanted to do. But now, in its fusion center form, it's being used to investigate and nab illegal immigrants. Fusion centers being used by regular law enforcement agencies to get all sorts of information about any kind of crime. In fact, one individual was interviewed by a professor here at Vanderbilt, said, this is a direct quote, people would freak out if they knew what we were getting through these fusion centers. All sorts of information is being obtained by these fusion centers. Again, they started off as being devices for detecting terrorism. Now they're being used for lots of other reasons. Cameras, designed, of course, to detect and deter crime, but in the United Kingdom, what are they used mostly for? To remove homeless people off the streets. We see a homeless person on a camera, we send the police in, get rid of them. They've also been shown to be relatively, well, let's just leave it at that. You can also make mistakes. You all have heard of the no-fly lists? That is, lists based on virtual searching that are designed to figure out who suspects are that we want to keep off airplanes. Well, you all have probably heard that Ted Kennedy was on the list, so that was presumably a mistake. I'm not positive, but presumably. The second individual you see here was an assistant attorney general in the Department of Justice. He was on the no-fly list. And then my favorite, this is a picture of Bob Thompson. He actually was on Vanderbilt's law faculty until 2 years ago when they removed him. No, when he actually transferred to Georgetown Law School, but he was on a no-fly list. He was routinely stopped. So mistakes can be made, even when the government's acting totally in good faith. And more importantly, based on records compilations, over 15,000 people of Middle Eastern descent were rounded up after 9/11 and subjected to interviews. Scores of these individuals were detained as material witnesses. Only one of them has been convicted for a terrorist act. And it was all started with the kinds of virtual searches we're talking about. So there can be some downsides to this in a very tangible way. There are also some less tangible ways in which virtual searching can have negative effects. Remember that argument that's often made against the regulating virtual searches, which is, I've got nothing to hide? I think it's a good argument. My wife makes it to me all the time. I don't care what you're writing about, Chris. I've got nothing to hide. They can do anything they want as far as surveillance is concerned. Okay, that's my wife. We get good arguments. We get good arguments. But it's also interesting to see how people respond to this argument. Daniel Soloff sent this argument out over his blog to see what people would say, and there were some good responses. If you've got nothing to hide, why do you have curtains? Okay, if you've got nothing to hide, can I see your credit card bills for the last year? If you've got nothing to hide, I love this one, then you don't have a life. Okay? It's just something to think about. Okay? On the other hand, I've tried this with my wife and she doesn't buy it. Okay. There also is research on what happens to employees when they're under surveillance. And it shows that employees, when they're under surveillance, when they know they're under surveillance, are more nervous and less productive and more conformist. And arguably, that's not a thing we want. Even when the camera surveillance is of public places, it can undermine that anonymity most of us probably expect when we're out in public. We don't expect to be tracked while we're out in public. We don't expect to be followed. So as one court put it in a case involving one of these GPS tracking situations, and I'm going to read a quote here and try to synchronize this with pictures. This is my most ambitious attempt to use PowerPoint. GPS devices like those used in Abdullah's case can reveal, as one court put it, trips to the psychiatrist, the plastic surgeon, the abortion clinic, the AIDS treatment center, the strip club, the criminal defense attorney, the by the hour motel, the union meeting, the mosque, synagogue, church, gay bar. Shoot, it finished before I did, right? But anyway, you get the point. There are lots of things can be revealed through these tracking mechanisms, and that was the point of this court that ended up saying the GPS searching was a Fourth Amendment search. GPS tracking was a Fourth Amendment search. Final point to think about in terms of whether we should be worried about this. It's a very amorphous one, admittedly, but nonetheless one that we probably ought to consider. It has to do as much with First Amendment values as privacy values. Okay, because one thing we treasure in this country is the freedom to associate with people, freedom to express ourselves, freedom to roam, freedom to define ourselves the way we want. And this kind of freedom, which is relatively vague, admittedly, nonetheless has been important enough that 2 Supreme Court justices have remarked how important it is. Here's what one justice said. I'll read the entire quote. Walking and strolling and wandering has been in part responsible for giving our people the feeling of independence and self-confidence, the feeling of creativity. And then the quote goes on. These amenities have dignified the right to dissent and have honored the right to be nonconformist and the right to defy submissiveness. They have encouraged lives of high spirits rather than hushed, suffocating silence. So that's a quote from one Supreme Court justice. And here's a quote from another one. Suppose that the local police in a particular jurisdiction were to decide to station a police car at the entrance to the parking lots of a well-patronized bar from 5:30 to 7:30 every business day. I would guess that the great majority of people would say that this is not a proper police function. There would be an uneasiness, and I think a justified uneasiness, if those who patronized the bar felt that their names were being taken down and filed for future reference. This ought not to be a governmental function when the facts are as extreme as I put them. Okay? Those are 2 Supreme Court justices responding to the kinds of thing I've been talking about. What's particularly interesting is who these 2 justices are. Okay? The first one, not surprisingly, was William Douglas. Those of you who know Supreme Court justices, he was a lion of civil rights. You'd expect him to say something like this. Okay? Who was the second justice? William Rehnquist. If there was a justice who was unfriendly to the Fourth Amendment, this is it. Okay? In the history of the Supreme Court, he has been the justice most hostile to the Fourth Amendment, and yet he said what I read you. He said it would be an unjustified police function, government function, to simply watch people as they go about their daily business. So I think those are 2 very powerful statements in terms of whether surveillance is okay or not. And I got to stop there, sorry. There's more to say. Oh, what happened to Abdullah? Do I want to say that now or make you wait till next week? Okay, I'll tell you one thing. He was innocent. Okay? He was totally innocent. He was a perfectly upstanding American citizen. And he wasn't an American citizen. He wasn't an illegal immigrant. Okay? But I'll say more about him next week because I want to say a little bit more about search and seizure before we get into interrogation. So, see you next week.